welcome everybody to the first stakeholder meeting for 2009 Group 1, the initial meeting. Today's date is Wednesday, September 4th. The time is 1:30. We scheduled this for up to 3 hours to 4:30. Just a couple of announcements to start with. Kind of the same as always of what we've always done here is this meeting is being recorded, so we have a formal record. Within a few days, the meeting written minutes and the recording will appear on our website. This allows anyone to listen to what transpired and have future input into the process. So what we're doing today is we are looking at 13 rules that the division and the Attorney General's office have laid out as Group 1, and we actually did that back in November. This was probably Group 2, and we moved Group 2 back to, or Group 1 back to Group 2 and moved Group 2 up, so that's what we're doing today. The agenda for this discussion has been set and it was published. We, or I, will attempt to stay within the agenda to ensure that we are able to cover all the topics that are on our list. Obviously, anyone wishing to provide comment, we're asking you to sign up the sign-up sheet that's going around, so we have a record of that. Again, remember that this meeting is recorded, so everybody needs to be respectful of the time that when somebody else is speaking, so that the record is, that we're creating here is clear. Please try to state your name, and this is hard to do in a meeting like this, but try to state your name before you start speaking. Obviously, we'll slip from that, and I'll be the biggest culprit of that, but try to state your name before you start speaking. We just ask that you're respectful to everybody, and you try not to interrupt anybody, let them finish their thought process. So with that, the agenda, like I said, is set. I'm going to go around the room, and we're going to have everybody introduce themselves for the record, and then I'm going to turn the bulk of this meeting over to Mr. Beebe and Mr. Jones. We're going to go through these proposed rule revisions one by one, paragraph by paragraph, for input from everybody. Okay? And then if there's any comments further comments at the end, if anybody comes in later and takes a seat, we'll make sure that they are heard if they want to be heard. And at the end, we will make a decision whether or not we need to have a second meeting, which we may. And if we have that second meeting, when that is, we've already kind of scheduled it already on our schedule for Friday, 2 days from now. Hope that if we need to have a meeting, that's not too short of a turnaround, but if it is, we'll have to reschedule probably the following week sometime, but we have a little flexibility on that. I believe that the rulemaking hearing for this, if we get everything sort of done, the hearing before the public hearing before the board, I believe is at their normal October board meeting, the third Thursday in October. I believe that's October the 15th, right? Tuesday. So, with that, just go around. I'll just go to my right. This is Bruce Duhoff, short-time director of the Auto Industry Division and the executive secretary to the Motor Vehicle Dealer Board.
Bradford Jones from the Colorado Attorney General's office, again on behalf of the Auto Industry Division as well as the Motor Vehicle Dealer Board.
I'm Leland Beebe, legal assistant to the Auto Industry Division and the Motor Vehicle Dealer Board, and the rules manager.
Steve Perkins, who's motor vehicle dealer.
Beth Spellerberg, Deputy Executive Secretary for the Auto Industry Division.
Susie Carr, Communications Manager for Enforcement.
Michael Downermuth here on behalf of Colorado Automobile Dealers Association.
Matthew Groves, Colorado Auto Dealers Association.
Frank Agos, Supervisory Investigator, Auto Industry Division.
Josh Dexter, Supervisor Investigator, Auto Industry Division.
John Opeka, I'm a Supervisory Investigator with the Auto Industry Division.
Tom O'Connell, Colorado Independent Automobile Dealers Association.
Corey Amen, Senior Director for Enforcement Business Group.
Chris Hartman, Agent in Charge for the Auto Industry Division. Chris Rouse, Deputy Director, Auto Industry Division.
Okay, so I'm going to turn this over to Leland. If now somebody comes in that we are sort of know wants to speak, I may stop this and just have them introduce themselves so they're on the record at that point in time. But I think it's time now to just jump right into these 13 rules. You should have all received, or you could have received a copy in the last email, and I think we really have some extra copies to hand out. I'll just turn this directly over to Mr. Beebe or Mr. Jones.
Okay, thank you, Mr. Buell. And since this is your last rodeo, I commend you on many successful ones recorded. Okay. As a matter of introduction, first of all, does everyone have a set of rules available to you to look at? They were sent out originally. I hope everyone has them. If they don't, say so and we'll get you. Okay. All right. Whenever we begin a staff review and consider what a set of rules that we might want to do something with, we have some certain considerations that are pretty much absolutely necessary that we have to do. And those are general considerations, and I'm going to run through them because we did consider them, whether or not we discussed them at great length. They were part of the background work that was done. And as I hit each one of these, I will indicate whether or not those did or do seem to apply to this set of rules. Okay, first of all, have any relevant changes to authorizing statutes occurred to which the board must respond? The answer to that was no. Neither when we set up the agenda this year, nor in looking at this group, did we determine that there was any change of statute that required us to review any particular rule. Okay? Second, are any provisions of existing rules, and this breaks down to a set. The first piece, outside the scope of existing authorizing statutes, that is not permitted under the authorizing statutes. Authorizing statutes change, and sometimes what was scoped originally with great accuracy cannot be scoped when those statutes change. There's nothing in this group that appeared to anyone to be outside the scope of authorizing statutes. Second, unconstitutional under Colorado or U.S. constitutions. So far as we can determine, none of these rules had any aspect that were currently unconstitutional under either constitution. Third, overlapping or duplicative of other rules. Now this is aside from there being necessary parallel rules for the power sports side and the motor vehicle side. There can be overlaps, again, that are inadvertent and sometimes were purposely once upon a time. No, none of these rules had that characteristic. Unnecessary because the authorizing statutes provide sufficient guidance. None in this group. There are statutes that provide guidance, but there's still the rules, at least as far as the staff could determine. Inadequate to achieve the aims of the authorizing statutes. For example, inadequate to address relevant policy matters like consumer protection, healthy business competition, etc. The answer there would be yes. Certain rules in this group meet that criteria. And we do have some.
We'll pause on, Brittany, do you want to take a seat up here, or are you going to have
Sure.
any comment? Sure.
Sorry, usually there's more people, so I just sneak into the back.
Well, then you get to sign in too, Brett.
And Brittany, just for the record, just since this is recorded, just state your name and who you are.
Brittany Moore, Legislative Coordinator for Department of Revenue, so I work with all the divisions.
We're just at the very beginning, so we haven't missed any. Okay, so, as I said, some of these statutes we determined were inadequate currently to address everything. Okay, the next criteria, written unclearly by modern legal drafting standards, including the plain English requirement and strict adherence to English language conventions of grammar, syntax, spelling, punctuation, etc. Yes, there are issues under that criteria. Okay, now, as another general point, which I kind of adverted to earlier, anytime we review rules, we consider, as we must, both sides of our house, which is to say the motor vehicle side and the power sports side. Sometimes we have a regulation on one that really should be on both. And so we do have to consider whether parallel rules should exist, and if we determine they should, to what extent they should deviate from pure parallelism. Okay, so that obviously is a consideration every time. Okay, now, in addition to the, and we've partnered, as you see, any of these rules that are in the packet today, wherever parallelism is part of this equation, it shows up in the packet. In addition to partnering of parallel motor vehicle related and power sports related rules, the rules being taken up today are taken up as topics. Now I want to make a sort of foreshadowing thought here. We will, at some point in the next few years, recodify the rules of this division, of this board. And that recodification will take us away from the sort of strange and old-fashioned adhesion, actually, between a statute's nomenclature and a rules nomenclature. It'll take us into a topical framework. So, this is an attempt to get us thinking a little bit on the topical side of things. These rules have inherent topical nature to them this time. So it was easy to do. So they're being presented as topical groups. Okay. There's also inherent in these topical groups the question of how uniform must considerations in a topic be. And I think all of you realize that the board has many licensees and many classes of licensee. We even have a brand new class of license. And so, to the degree it's possible, we want to avoid any challenge that one type of licensee is being singled out for a particular treatment that another type of licensee is not being singled out for. It sets up questions of equal protection, things like that. So we're always attentive to where we can uniformize. And, I would also kind of maybe humorously say that when you don't have uniformity, where you should, you have created the devil's playground for attorneys. And Michael's high. And I resemble that same thing, Brad does too. The point being that we want to see the groundwork to be equivalent where it can be legally, so that we avoid those eventual crazy arguments that end up often costing a lot. All right, now, so today the order of the rules being taken up will be exactly the order that's in the packets that you have, which means we're about to launch directly into those packets. If you have any questions about this generality that I just discussed, please go ahead and ask them now, or comments. Okay, seeing none. The very first rule set is the material misstatement set, the topic. Now this has some interesting history. The statutes upon which these were based existed even before 1991. Now you may know, if not you will now know, that this agency under one name or another has existed since about 1947. Okay. It had a tremendous growth spurt as far as regulation somewhere in the 80s and 90s. And when that began to happen, it was based upon legislative change that occurred. The material misstatement was a fairly old consideration in the statutory scheme of the board. The 4 rules in this set all became effective at the same time, on November 30th of the year 2000. Okay, they've never been revisited or revised since that time. Now, we don't currently have either the legislative history or the rulemaking history easily available to us. Back in that day, things were handled differently than they are today. You can get a lot online today, but you can't in the old days. So we'd have to do a lot of deliberative research to get very far, and we didn't need to do that. However, what limited research was possible suggests that both the General Assembly and the Rulemaking Board were greatly concerned to address perhaps the most fundamental of all concerns to a decision maker: that truthful statements, not lies, appear on an application. For emphasis, let me paraphrase that slightly: to ensure that truthful statements, not lies, appear on an application for a license. That is the reason that the material misstatement definition exists and the prohibition against making material misstatements on an application exists. The concern to avoid making decisions based on lies has existed throughout human legal history because individuals have sought advantage by deception. Reasonable and ethical governments and courts have universally recognized that only the truth matters, because wrong decisions can easily result if a lie rather than the truth is before a decision maker. Persons take oaths in our system to tell the truth in court. Persons make declarations on penalty of perjury frequently in documents in order to set them up for the eventual possible criminal charge if they had lied. As the English common law developed, refinements to this concept occurred. As codified law, statutes, codes, regulations evolved, further refinements were made until today. A lie is seen broadly to include not only the introduction of erroneous facts into a decision-making process, but also the failure to introduce facts when those are required. In other words, an omission. Whether a lie matters to a decision maker has also evolved as a concept. When a lie matters, we would today call it material. And there is frequently room for argument on whether a given lie is or is not material under the circumstances. As time passed, decision makers recognized that a lie could be expressed in as many ways as the human could communicate. That is, by oral expression, written word, tangible marks, in answer to questions, signals and signs of various kinds, up to the current electronic paradigm and its modes of expression. Finally, as time passed, every form of recognizable person became a possible author of lies to decision makers. True, non-natural persons cannot speak for themselves, but require natural persons to speak and act as their agents. Can a corporation, LLC, partnership, association, etc. lie? Yes, but only by means of an agent. Some natural person, for example, an owner, a member, a stockholder, an officer, etc., that tells the lie on behalf of the corporate or the other entity. When the General Assembly authored the material misstatement on an application ground for denial of an application or later discipline for the same, and the Rulemaking Board at that time authored its definitions of material misstatement, both were operating in the modern era. Both wanted to deter lying on applications when such lying could influence the board. The General Assembly left the defining of that term to the board. The board wanted to make sure it captured as many persons of all types as could be influential in the application, and make sure it captured as many ways as it could easily illustrate of how such lies would occur. What we see in the current rule formulation is an applaudable effort at drafting in a style more acceptable in the year 2000 than now. We see a definitional structure in the style of an extended definition, rich with examples, but that is no longer the plain language style of definition preferred by modern drafters and by courts. The modern style goes to basics and seldom lists or illustrates unless absolutely necessary. In the staff discussions and the development of the drafts that proposed changes before you, there was and is nothing new and nothing novel. There is just a reduction and a simplification and a determination to ensure that the definitions don't treat any class of licensee differently from any other class of licensee based on the central concept. Now, because the staff discussed this, I will point this out. It would have been desirable, and it was possible, to consolidate the motor vehicle definitions together and the power sports definitions together in a single definition. But there is no place currently to put such a definition in the framework of our statutory / regulatory naming convention. We can only do it when we go to a topical convention rather than something that mimics statutes. We could not put that all together, although we knew that would be a great idea. Okay. And right now, the Attorney General, when I'm about to refer to him, has disappeared.
He's coming back.
Oh, good. All right. All right. I'd like at this point to ask if Assistant Attorney General, Senior Assistant Attorney General, Brad Jones, has any comments that he'd like to make.
Yes, thank you, Mr. Beebe. So, in addition to what Mr. Beebe kind of covered already, a couple of things that stood out in our drafting process from my standpoint. The first being that material misstatement, the quoted language was not consistent with what is listed in the statutory text. So it was expanded to material misstatement in an application for a licensee, just to clarify that it was specifically pertaining to that. Additionally, something else that I personally push for based on our enforcement hearings on this issue, not just limited to the auto industry division, but other DOR enforcement divisions, is the concept of the responsive mark. So if you're checking a box, other divisions have encountered licensees or applicants, I should say, that did not believe that constituted a material misstatement. So we just wanted to make that abundantly clear that if they checked the wrong box, that could constitute grounds for a material misstatement. Additionally, I just earlier this week, as in yesterday, received the new statutory books. And we were accounting for the new license, the business disposal license, in drafting this. However, I just discovered that it would actually be under a different rule. So we are going to have to add a rule that mirrors the first proposed rule under 442121 3A. And that is going to be 442121 6.5A. And just so it's clear, I'll read that out. 6.5 concerns a business disposal license, and it says, which may be denied, suspended, or revoked on the following grounds. And the first subsection is subsection A, which is making a material misstatement in an application for a license. That is consistent with the existing language for the other license for motor vehicle dealers, wholesalers, wholesale motor vehicle auction dealers, and buyer agents, and used motor vehicle dealers under subsection 3 of Section 121 under Article 20 of Title 44. So I don't anticipate there would be any changes, but I just wanted to point that out now that I'm looking at the new statutory provisions that have been published earlier this week.
And that licensee class does not have salespeople, so there'd be no reason to have a separate related rule from that.
So, Mr. Jones, would the new rule read almost exactly the same as the proposed rule here?
Thinking off top of my head, yes, for the proposed rule for 4421-21-3A.
The motor V part?
Yes.
Before the, in the set of the material mistake rules, there are two companion parallels right now. The first companion parallel is motor V, the second companion parallel is power sports, and within each one of those, there is one rule applicable to salespeople, another rule applicable to any other licensee than a salesperson. And what Mr. Jones has now pointed out is in the motor V side of this, we would have to add one more dealer-related rule. So it would resemble exactly the rule I'm about to read, which will be the dealer-related rule.
Do we need to read the rule into the record? Because we
don't need to.
Well, we stopped doing that 2 or 3 years ago, and I don't think we need.
Yeah, we don't need to, as long as everybody's comfortable with that.
Is there anybody that needs us to read out the rule?
Yeah.
Anybody that wants to leave the room alive?
It's an ADA feature of rulemaking, okay?
We stopped it 3 or 4 years ago under the guidance of the Attorney General's office.
Yeah. Okay. Then I shan't read it.
So I guess, just jumping ahead, gentlemen, are we ready to just open this up to look at the new proposed rule to see what concerns that anybody in the room has, if you have concerns?
This is Michael Domermuth on behalf of CABA. Under the material misstatement, there is subparent D in the definition that I have some concern about being potentially ambiguous. That could affect the outcome of the board's review of an application. That could be anything. And, you know, that sort of ambiguity, as Leland pointed out, is the devil's playground for lawyers. And it appears throughout all of the proposed rules. I don't know how to deal with it. I just wanted to point out a concern I have with it of being potentially ambiguous, because it really says the board can consider anything they want with regard to an application.
May I respond? That's a pretty tricky one, Michael. The original thought I had was to incorporate a reasonable person standard there. It's difficult to place a reasonable person standard in the shoes of the board, realizing that is who we're talking about here.
Right.
Yeah. And I mean, that could reasonably affect the outcome. It changes the sort of the scope of the question you're raising to whether or not that is a reasonable thing for the board to have a concern. This comes very close to the kinds of discussions that you read in law today on what constitutes perjury and when perjury matters. And it's a big problem. It's a legal major concern. What is material? And I'd invite anybody to provide what would be a better definition to put there, because that's what we're dealing with.
Well, it's anything the consumer says it is on the other side of the coin,
Yeah.
from the spending case, but that's not helpful here, I
No.
realize that. I mean, as long as it's false or misleading, I don't have a problem with the next part, which would say that could affect the outcome of the board's decision. But this doesn't say that it has to be false or misleading and could affect. It's separated by a comma, and so anything the board wants there, they could have in terms of denying an applicant.
Well, the way we were approaching this, and I'll have anybody from the division that participated, is that this is all taken together. That's why we put it in this chain, or this list. And so all the subsections A, B, C, D, and E need to be taken together in order to qualify as a material misstatement. So I can tell you from an enforcement side, the way I was looking at it is that it would be false or misleading that would result in a different outcome. So,
So that would give you the conjunctive rather than the or.
correct.
All right.
And the word "and" right after subsection D, where it says that could affect the outcome of the board's review of an application, and is what brings all of those components together. So we would have to be prepared to demonstrate why this was a false or misleading and why it is a concern, not we would have to tie it into why it's a concern based on the representation that was on the application or the omission that was left out of the application. Anything else? Do you have any questions based off?
No, I just wanted to raise that as a point of concern I have with the new rule, and you know, I think it does open a door to create a potential ambiguity here that you may not want to open. But that I understand your reasoning, and I agree with it, Mr. Jones, and so I don't have any problem with that. I just, from looking at it from a lawyer standpoint, that's one issue I have.
Oh, absolutely.
Yeah.
Thank you.
And I see Leland shaking his head that he had the same issue
Oh, yeah.
in drafting it. So.
Yeah. Yeah, that was brought a confession here. This was the most challenging thing to draft
Right.
of all the years I've done any drafting of any rule. Because to get to the base features, you'd think it'd be simple until you get down to those exact words that you're talking about.
Right.
It's quite hard. Was there any other concerns about any other part of this?
I guess my question would be, Mr. Donovan, is the issue that you raise, is that something that could get in the way of us walking out the door and have, a consensus that we would move forward with this as written? Is there a better way? Is there a grammatical way to fix your concern without changing what Mr. Jones said? Is there?
Well, as long as there's an implied "and" after false and misleading, then no, I don't have that big a concern with it. If it's false or misleading and material, that could affect the board's review of the application. That would, I think, help satisfy my concerns about the open door, that just having that parenthetical there.
So are you proposing that we add the word "that could material affect the outcome"?
No, I think, no, not.
I just
that
wanted
was-
to make sure.
Yeah, no. The misstatement has to be false, misleading, and material that could affect the boards.
Absolutely.
With that comma there, my concern is that you've left the door open for an incredibly broad amount of discretion with the board with regard to an applicant. I'm not gonna lose any sleep over it. You know, I just wanted to point it out as a potential ambiguity that maybe we should consider some way to try to fix it before it ends up in some hearing or some courtroom somewhere.
We can try. I couldn't make any promise. I'll look for any other kind of expression that might work there.
So we would have the same issue, Mr. Donmuth, on number 2, which is.
Right.
Yeah.
And I think this model is used in the power sports as well.
Yeah.
So, and again, I'm not gonna lose any sleep. I've never had a matter that's gone this far, but I do come to these to participate and try to point out potential
Absolutely.
problems. And that, in my mind, is a potential problem because of the broad grant of discretion it creates with the board. You know, I'm trying to think of a hypothetical that it might apply to, like someone, you know, spent 2 years in college and then claims on their application they graduated from that college. Is that really material to the board's decision? You know, people puff up their resume all the time, you know, so that's just one example I would think about that maybe could give pause to somebody who would look at that and say, you know, that's just too much discretion. It's too big a door to walk through.
Michael, would you object to importing the reasonable person standard into that phrasing? Because what you just suggested is an example for a reasonable person standard in that location, in that elemental analysis would actually say, wait a minute, that just isn't that big a deal to be material. It might restrain the board under that circumstance.
Right. They might get some legal advice that that's an unreasonable consideration and you fall on it. So that would be helpful.
What if we just remove D completely?
No,
Why not?
because that's the definition of material.
Do we have that in the current rule? We have D or some form of D in the current rule.
We have relevant. The word relevant. If we
Everything that I know about the literature on the term material or materiality has to do with outcome. So we, you know, whether you call it outcome, you call it result, you know, the relevance is the outcome.
So what you're trying to do with D, Leland, is get to what material is.
Yeah.
And so why don't you just come out and state that?
Because then
Material
word
information
word.
is anything that could affect the outcome of the board's review of an application. Make that a lead-in sentence. And then a material misstatement would be A, B, C, and E.
So altering the order of the elements.
All right. Or your approach to adding the word reasonable, that could reasonably affect the outcome of the board's review of an application. I mean, I understand what you're doing, but you sort of you're mixing up your subparts here.
Mm-hmm.
was your proposed addition entry?
Well, starting out with or concluding with a sentence that says, material is anything that could reasonably affect the outcome of the board's review of an application.
Oh,
Making that a standalone sentence.
and
So then you've got one definition of material and then another of material misstatement.
interesting. So material for purposes of this rule equals,
Means anything that could affect the outcome of the board's review of that application.
Right. And I do like the insertion of Leland's suggestion to add reasonably affect, because that helps avoid some discretion.
some abuse of discretion.
Right.
Interesting. Okay, so. See, yeah, this is all kind of logistic, but the current way that we've approached this is to lift the language right out of the statute and say material misstatement in an application for a license, okay? Rather than just say material misstatement. We don't have to do that. The problem is that it makes it simpler for application purposes. We can't go, I should have said this in the beginning. If we could have gone to the highest possible level for this definition to exist, which would have been desired, so that it could have applied in every context of the licensing and, other regulatory process. But, we would have, but there's no place to put it.
Right.
And so we couldn't go there. And so narrowing to this particular aspect could control where we deal with this most of the time. I mean, it's where everything is. And we could go back to material statement. We'd have to restructure this considerably.
Yeah.
But I think we could achieve what you're trying to achieve.
We could just add it at the end. So we take out D and then we put the sentence, for purposes of this rule, material means any information that could reasonably affect the outcome of the board's review of an application.
Bam.
Okay.
And that would change the list from A to E to A to D, with E becoming the new D.
Yeah.
So, and then we would tack on that sentence at the end of each of the other proposed revised rules. So 442121 6A, 442121 6.5A, and then the 2 power sports.
I think that's an excellent idea, Brad.
Okay.
That works.
Any other comment? Mr. O'Connell, see any issues with that?
Nope.
Mr. Perkins, two-time former board member, two different kind of eras.
I was mentioning to Beth just briefly, as the board member, we often see, and I don't know how you qualify it, whether it's, you can't do it by age, that relevant false statement, the 21-year-old that thinks that his record has been expunged, and so he answers it incorrectly, and it just ties up hearing officers and goes through the process, and then they recommend either a regular license or, T's and C's, and then the board approves it. Is there some latitude or some direction that could be given to the division on certain circumstances that would just go ahead and grant that license and expedite the process and save time and money?
that applicant needs to read the cover letter that's posted right before the application online, which clearly says, even though you think it's clean, it probably
That's
isn't.
assuming the 21-year-old knows how to read.
Right, or will read. Or will read it, right?
If it's not a video on his phone that he can't listen to while driving down the road.
YouTube instruction on how to fill out your Colorado salesperson license, yeah.
You know, one of the things that it's kind of funny, but I think the point is that Mike is right. It clearly states that in the cover letter.
Right.
But the cover letter technically is not part of the application. So maybe there's a way in the future, because you don't have to go into rules to change an application. Maybe there's a way the next time we change the application to put a more definitive statement like that right in the application, right before that box of questions that have to do with that. And
All
then-
caps, it says, "We know."
Then we hit it twice. We not only hit it in a cover letter, but we hit it in an application. Because, Mr. Perkins, you're exactly right. I mean, it's a material statement, so you deny, then you either go to hearing or you call the person up and say, you have the choice, your choice, you can either go to hearing or you can reapply and correct it.
Right. Right.
Well, and Steve, another thing, you know, the board itself could, with a rule like this in place and with its experience, could formulate some kind of a guideline that the division could, just as you have done with other issues. It would be difficult, but, you know, it's always possible. Yeah.
Okay, with that change, everybody reasonably happy with moving that forward? Okay.
Yes, sir.
Okay. Let's jump,
The really fun one. Yep, we're ready. Okay, the second set is really a singlet, having to do with the power sports only rule, which we have euphemistically, historically always called ANSI requirements. And, okay, so, this rule is unique to power sports. It's based upon a Colorado statute implementing a non-governmental standard for a particular set of power sports vehicles, i.e. off-road, all-terrain, four-wheel vehicles. The standard to which the statute and the current rule formulation refers is sufficiently important that it is incorporated into federal law. The standard has evolved from a purely voluntary original standard through a series of published versions applicable according to specific model years and time periods. This is the second time, many of you were here the first time, that this rule appears for our review. The first time was 2 years ago, in Group 2 of the 2017 rulemaking agenda. Revisions modernizing the rule were recommended to the board by the stakeholders, but the rule revisions did not progress, and for one reason. Legal concerns became an issue over how to reference a non-governmental standard in a Colorado regulation and how to make that standard available to the public. That was a historic moment of realization that we had a change in the APA, and Mr. Jones will talk about that in a minute. Okay, the rule as you see now has been rewritten to capture each of the historic versions and their respective applicabilities across the model years. It's also been rewritten to include the best understanding today of how to reference the standards and how to offer them to the public. Now, I'm going to throw this in right here because it's kind of important since this particular gentleman would have been here, and his, shall we say, word on this is kind of important. Jerry Abood, who many of you know and has worked with for a long time, who heads up the Power Sports Viewers Organization in Colorado, couldn't be here today, but he asked me to specifically state for him that he has reviewed this draft version carefully and finds that it is, as he put it, spot on. He agrees with it in its current formulation and sees no reason to make any changes to it. Okay. Now, at this point, I would like to turn to Senior Assistant Attorney Brad Jones for him to talk about this legal matter and how we ended up with that tail end part of the rule in the way it is.
So many of you probably remember this rule as Mr. Beebe referred to it. This was something that we did, worked on a few years ago. We ended up pulling the rule, and that was because there was an incorporation by reference requirement that the Office of Legislative Legal Services has focused on in recent years. And specifically, there were some concerns about how we reference the SVIA publication materials. When Mr. Beebe and I started looking at it, and we thought we could address it after the rulemaking just because it's more of a procedural requirement, we also noticed that there were some issues about a new version coming out, and we wanted to wait until the new version came out so we could do an updated rule instead of promulgating the rule and then coming right back to it. That took substantially longer than either of us thought, and because of that delay, it's been pushed until now. The incorporation by reference statute that I'm referencing is under the APA. It's section 24.4, 103, subsection 12.5. And basically, there are certain requirements that an agency has to go through in order to incorporate some type of statutory text or any guidelines or any outside material into any of its rules, just so it's abundantly clear where this information is coming from and that, frankly, it's reliable information. The SVIA, the Specialty Vehicle Institute of America, is the author, publisher, and copyright holder of the ANSI /SVI standards that are listed out in this proposed rule. That includes the 2001 standard, 2007 standard, the 2010 standard, and the 2017 standard. I spoke to an individual at SVIA. They confirmed their materials are copyrighted. And what that means is that unlike other materials that are in some of the state agencies' rules, these are not accessible in their full version online. There is a cost component associated with obtaining a copy of these. Certified copies can be obtained directly from SVIA, the agency. AID cannot certify the copies by themselves. But we will have copies that are accessible and reviewable at the agency in accordance with the provisions that are listed out under that incorporation by reference. Additionally, we provided information as required under that statutory provision regarding where additional copies can be obtained directly from SVIA. And so that is why we listed out the full address, the phone number, and the website of the organization. We want to be as inclusive as possible so somebody can review this and know who to contact. Again, this is an effort across the board for all state agencies going through the rulemaking process. So that's why it's a little bit more verbose than some rules in the past, but this is the change across the board. Any questions based on that information?
So you said it has to be, I guess, accessible and reliable. Is there some determination within Colorado law that if it's not reliable, it can't be adopted in Colorado?
No, that was just me adding on why I think this occurred. And just kind of talking with other colleagues throughout my office. There's nothing specific that I'm referring to in the statute. But I will tell you that there's a concerted push to make sure, at least from the legislative standpoint, this is my understanding, that individuals that are reviewing rules know exactly where they can go to obtain this information, and thereby they will know that it is reliable information, where it's coming from, why an agency that is promulgating a rule is looking at this information. It's trying to be more transparent. That's the gist. I did not I had no involvement and I was never part of the process that occurred regarding the change to the APA to include this information. So I'm having to rely on other individuals that have a little bit more knowledge, but that was kind of my understanding and takeaway from it.
But now if AVSI changes their standard, we're stuck with the version that we adopt today, right?
Correct. And that is pretty consistent throughout the state agencies. It is a frustration. Some standards change more frequently than others. I think you're well aware of that. Definitely with changes of administrations. So I think under the current guidelines that have been pushed out by the governor's office and the legislature, the review process will kind of account for this. I don't anticipate it's going to be a change every few years. That could change, but from my limited discussions with SBIA, it's probably going to be at least 4 to 5 years before they make another change. The important thing to note, though, is that under the APA statute, it specifically says, let me just pull it up so I don't misstate this. Specifically says that the rule needs to state that it does not include any later amendments or additions of the code, standard, guideline, or rule. So that's why we have no language in here saying any subsequent additions or versions of this are automatically incorporated. So you are correct, we would have to go through the rulemaking process to account for any changes in the future.
The good thing is that it's set up now so that that kind of change coming at the tail, it would come at the tail end of that list. And it would be a very simple matter to know when it began its enforcement at the federal level, because that is the trigger point for these. The other thing to realize is that 2 years ago, when we looked at this issue, we looked at the possibility that the federal government, because it's required this, might be taking a copy and putting it into its regulatory scheme, therefore making it possible to reference its regulatory scheme where a copy existed. No. That's not what they did. So we kind of were stuck. We had no end run available. This is the way it is.
So, Mr. Jones, what happens if they move and this address is no longer accurate?
That is another frustration and concern.
What if the auto industry division moves?
No, don't go there.
Never again.
We'd never do that.
You don't have the website for the auto industry division in here, which might be helpful. So you can't eliminate these addresses, because if they move, does this regulation become compromised?
It would be best that we reopen it and make the change.
Okay.
But we're just including as much information as we have right now to assist somebody in locating. That's again why we're including that, the address, the phone number, and the web address. For what it's worth, I did ask the lady if they were planning to move anytime, and she said to her knowledge, no. I don't know how high up in the chain of command she was there, but that is a concern. That is a concern that I've talked to some of my colleagues throughout my office, and they're well aware of the frustrations and the problems that can arise throughout all the different industries that are regulated by the state of Colorado because of the requirements in the APA. So I think every year or two, the division will have to look at this and just kind of confirm if there's been any updates or any changes to any of the information that's listed here.
Yeah, I'm sure we could rely on the power sports industry to help us to.
And you don't want to have it on the website someplace so where somebody can go to the auto industry division's website and find it as well.
The address or the actual standard?
The standard.
I don't think that we can
We
do that due
can't
to
do it.
copyright issues, so I don't think we can actually put it out there in that format.
So-
But as far as SBIA's address, I've been here for 18 years and they've been at that location the whole
That's
time. Now, does that mean they won't move? We were here for a long time and we moved, so point
Right.
taken, but it'll be a simple fix to a rule.
And there's a specific requirement that we have copies, or the auto industry division have copies. We also have to purchase and send a copy to a public depository in distribution center. And they're just trying to make it as accessible as possible, but staying within the confines of copyright laws.
You only have to send it to the public repository because it's copyrighted.
No, that is a specific requirement, is any material be sent to the state publications depository and distribution center. So,
And that's the same whether you're adopting a third-party standard or adopting another state standard?
could you repeat that?
That's the same whether or not you're adopting a standard set by a third party or a standard set by, say, another state?
Yes, because it says any code, standard, guideline, or rule that has been adopted by an agency of the United States, this state, or another state, or adopted or published by a nationally recognized organization or association.
And if the state of Colorado didn't send it there, would it invalidate the rule?
Oh dear.
Just curious.
We will make sure to send, I'm gonna skirt that issue.
Yeah.
That is a good question. Hopefully no state agencies.
Okay.
encounter that. So,
I'm not gonna comment.
Any questions, more concerns on this one? It makes me feel more comfortable that Mr. Aboud has weighed in on this. I mean, this is his area sort of expertise. And he has weighed in and thinks that this is pretty solid. All right, with that, we'll move that one forward. The next one is set 3.
Yep. Bruce, I leave it to your discretion if you think that we need for a break.
All right, so we've been at it an hour. We can do this one and take a break after this one, or this one may require some. Is everybody okay for a half an hour or so? Okay, let's move forward.
John is.
I am now.
That's on the record.
Okay, so we're to rule pair 3, compensation disclosure. Okay, with only limited tailoring of terms, the current motor vehicle and power sports versions of this rule are identical. When I say limited, I mean really, it's only because somewhere it says power sports instead of motor vehicle. It is a parallel rule now. The foundational statute has been in existence for a very long time. The motor vehicle rule in the current version has been enforced since May 2002. The power sports version naturally appeared after the power sports came in about 10 years ago. The staff spent considerable time reviewing and commenting on the existing rules, ultimately agreeing on the current proposed revisions in order to capture all the basic concerns, to modernize the language, to achieve greater clarity, certainty of responsibilities, and appropriate record identification and retention. Additionally, the staff were concerned that strong statements be included to alert consumers, negotiating dealers, actual vehicle owners, and others that wholesalers can never be involved in this process. The thrust of this rule is consumer protection in the unique context of a sale, exchange, or lease of a new or used vehicle, when that transaction is being negotiated between the consumer and the owner of the vehicle, who is not the negotiating dealer, by a used vehicle dealer acting as negotiator. Well, okay, now be a used car. Significantly, such negotiations have a transactional cost that is borne by the consumer through some dollar remuneration to the negotiating dealer from the consumer or the actual owner of the vehicle, or both. And at this point, I'm not reading this into the record. I certainly recommend that you have in front of you not only the rule, but that you look for a minute carefully at the form that goes with this rule. A not required form, but a form, that refers to every piece of information that currently the rule proposes is important. And Brad, did you wish to chime in here?
Yes, so one thing I wanted to add is about the specific proposed form itself. During internal discussions at the division level about potential changes, one issue is raised on the Driver Protection, Privacy Protection Act, and that is something I looked deeper at. There was a concern about whether we could provide the name of an individual private owner on this document. So that's something I looked at. The specific statutory provision at the state level is subsection, or is, I apologize, 42-1-206 subsection 1B. And that refers to the U.S. Code, which is 18 U.S. Code section 2721, which is the prohibition on the release and use of certain personal information from state motor vehicle records. Now, digging a little deeper, motor vehicle records are defined as any record that pertains to a motor vehicle operator's permit, motor vehicle title, motor vehicle registration, or identification card issued by the Department of Motor Vehicles. So this information, which is going to be part of the sales documents, I don't think qualifies as part of as a motor vehicle record that would fall under this. So in the middle of this proposed document, you'll see where there's a line in it says print full legal name of current owner, and in the brackets below that it says provide the name only when the current owner is a dealer. I think we can just take that out. We can leave the dealer license number, but maybe put in brackets after that if applicable. Again, there was a lot of concern based on the previous version, and I'll have anybody from the division that kind of weighed in on this speak up, that we provide a little bit more information regarding the year, make, model of the vehicle, as well as who the players are involved in these sales. If you look at the old version of the compensation disclosure form, again, it's the basic information that needs to be included, so dealers could go well beyond that. But we wanted to, the division wanted to provide a little bit more information in these documents going forward.
So, Mr. Jones, so this is Todd. So if a dealer uses this form, it'll be a safe harbor form that includes everything, and they don't have to add anything if they don't want to.
From my understanding, based on the conversations with the division, I believe so, but I'll leave it to the discretion of the division representatives.
I think that's what the rules, I think the new rule says that it has to have at least this information in here. If you want to have your own form and include this information or more information you can, but you have to have at least this information. So if you use this form, I think, my answer to your question, I think that would be, I don't think we could go outside of that and say you didn't provide something you should have. If it's on this form or your own form.
Okay. Thank you.
Any other questions or comments?
This is Steve Perkins. I have some questions. Pursuant to sections 40, 420, we get into statutory regulatory language. The old document just said pursuant to Colorado law. I don't know of any other forms that we really reference statutory language. It just looks like it's legal mumbo jumbo, and wouldn't that just suffice? One question. I don't know that it comports to the statute, because some of this language is very similar to what was discussed in 2002. Surprisingly enough, I was around. The statute speaks to prior to completion, and this speaks to prior to actual negotiation. And that's really impossible to do. Not from a practical standpoint, it's impossible to do from a used motor vehicle dealer, because not every transaction starts as a, for lack of, broker transaction, selling a vehicle that's owned by somebody else, right? If you were a used motor vehicle dealer and that's exclusively all that you did was this brokered transaction, then that would really be simple. Here's what we do, here's how we do it, right? So we may have a prospect or a client comes to us and they start wanting to buy a late model used car. And then there are times where a new car dealer will sell us a new car, we'll take title and turn around and resell that. I happen to have my own lease company, so through the process, I may determine that I'm gonna be the lessor and I'm gonna bill and collect it. And then I have my own banks and credit unions that wouldn't involve a brokered transaction, and then you have the true brokered transaction. So the brokered transaction may come in at the very end. Well, why don't I just get a new car and lease it through Ford or Toyota Motor Credit Corp? So to put before actual negotiation, before the process. So that means I have to say to this prospect, I need your full legal name, and I don't even know that that's going to happen. This may take, it might be days or weeks or months into the process before we actually end up doing a broker transaction. So I don't think it comports with the statute. I think you can say prior to the completion, and that's what the statute reads. The rest of it, I have a document that, of course, we put forward to our customers, and it does spell out the new car dealer, who that is, and has my license number and all that information. I checked this, I don't have the year, make, model, and VIN, and I think that's good information to have in. And then in closing, this requirement is done by the used motor vehicle dealer, and now you're asking the owner of the motor vehicle, who really is not really part and parcel to this document. We generate it for our client or prospect, and now we need to make sure that they get a copy of it, and they retain that copy, or they're in violation of the regulation. Right? Certainly within their deal jacket, if anything was ever, there'll be compensation paid to a used motor vehicle dealer as a result of the transaction. And that was also discussed in 2002, that the burden of having this form being required to be held by the owner was just onerous. And it falls under the used motor vehicle dealer license statute.
Steve, how is it onerous to ask the actual owner when it's a licensed dealer?
Well,
it's going to have a good question anyway.
It's a good question. I mean, we certainly have, and I think most of the used motor vehicle dealers that are in this business have a separate form that the new car dealer is required to sign that tells how much they're paying us as a result of this transaction. So that's going to be in there. But, we have different salespeople, there's different delivery people that drop off these vehicles. And so to always make sure that this document got back to that owner's file, we're not in control of that.
You wouldn't just send it to them in the mail?
Oh, I mean, we could scan it and email it.
Yeah.
Right. So what purpose does that serve for the owner to have this document that was with our client?
Well, some of it comes back to when we're looking in the deal jacket. If we end up at the other dealer, not your dealership, the other dealership,
Right.
It clues us in that you were involved in the transactions. I mean, when we go look at that, if they don't have any of that paperwork in there, how do we know that you were an intermediary in there?
Because when that is accounted out, there's a cost of sale that's paid to the used motor vehicle dealer.
That's not always kept in the deal jacket.
Well, it's kept in every, I mean, I take your word for it, of course. I've worked at a lot of dealers, I'm not
Right.
known where that wasn't part of the deal jacket.
What's that?
Because the paperwork's on the franchise deal?
Well, this isn't only there are situations where this may not be a new car. This may be a used car that's brokered through somebody else. So we may have disclosure issues like failing to disclose to them. And this gives us, when we call the consumer, that they realize you're involved in the transaction and they weren't dealing with that other dealer.
Are you aware of any brokered transactions where it was a used motor vehicle dealer?
I'm not, but the statute allows for it, so
Right.
it's still a matter of we have to be prepared for
Right.
that situation.
Right? I mean, I'm not trying to prohibit you guys
No,
from doing your jobs, I understand. It's just, to me, it's another burden that doesn't need to be in place. I think there's documentation in it if you look at a deal, but
Okay, this was a very extensively discussed rule. When we put this on the agenda, frankly, I never looked at it, and I think we all thought this one, no controversy, nothing about it that would really stand out. And then we get into it because of our internal process, and people are saying, well, wait a minute, this isn't clear. Wait a minute, what if, what if, what if? And what all the what ifs really come down to, and all the lack of clarity really comes down to, is that in the enforcement process, you really want to be able to see how things connect. And if the connections are not part of the regulatory scheme, then the investigators are going to have to find workarounds to get to that information, or the information's invisible. The connections are just not there. And for this instrument, this little workhorse instrument, okay, it has, I mean, it's an unusual thing, this brokered transaction. In a way, it's unusual. And that you have multiple parties involved. I mean, you could have another consumer who's the actual owner, yes. You could have a used dealer, you could have a new dealer, you know, any one manner of things, just not a wholesaler. And so right there, you have this panoply of mischief waiting to happen if we don't know all about that. And then we have, okay, the deal is consummated. Who has a record? Well, obviously, who does the brokering must. The negotiating dealer must have that record. And that's never been a question. But this other side of the coin, okay, do you want the consumer to have it? Well, yeah. They're agreeing to spend some money for this whole deal. But you want to have the party that may be the very first stop in the road of an investigator looking into a deal have that record? Yeah, that was what we figured, that it's important to have it sitting there. Has it ever been a problem? Well, no. Could it be a problem? Yeah. And it's just, you know, we don't know how much burden it is. Honestly, we don't, Steve, because we don't do it.
well, I understand.
Are they not executing other paperwork that goes to that dealership?
Oh, sure. I mean, it's all their paperwork.
So why not include that piece of paper with the other documents?
Well, the burden is on them, right, to then be in compliant with this regulation, right?
Well, both sides. I mean, you and the other dealer, the burden is there.
Well, yeah, we've been, I don't say it's a burden, we've been in compliance, right? We've been using this form since 2002, so, you know, that's not an issue. And again, it was talked about because in 2002 that it wasn't part of the owner of the motor vehicle, right? So,
Yeah. Going back to what you first brought up, which is the tracking of language out of the statute, as to the, you know, when the person can sign and should sign the thought behind having it happen prior to the negotiation is that the individual who is part of this process, the consumer, is being given a full alert of that event going on. Because they're the ones that have to pay.
Right.
Whereas if it's at the end of the process, I mean, where do they have the choice is the question. I mean, do they have the choice after they know all the facts? Or do they have the choice only after they've agreed to everything, and oh, by the way, this is gonna cost $200 for you to do this?
Well, I can only speak for me personally. We never charge a consumer a separate fee and then receive a fee from the owner of the vehicle.
Okay.
And that's stated in my disclosure form. Could somebody out there do that at the 11th hour, say, oh, now you gotta pay an extra fee of $200, and somebody say, right, no, or it's too far down the road? I mean, I understand what you're saying, but that's not the language in the statute. And the
No,
negotiation
You're right.
is complicated. Now, certainly when we talk about our different types of transactions, consumers today, well, how do you get paid, right? And on this particular transaction, the owner of the motor vehicle pays us our fee out of that selling price, right? Because we're not going to ask you for a separate fee, right? And maybe there's some people out there that do that. That's really kind of what generated this statute in the first place, was that there were unscrupulous dealers out there that were taking from both sides of the transaction, and that one they wanted to have a bright light on, right? So, but it would be impossible to comply with this regulation before negotiation.
Right.
It just is impossible.
And I think tracking that language, we would be, you tell me, could we actually do this the way it's written, given the statute?
Well, it does say prior to the completion of the sale, so we were thinking that, I mean, this is definitely prior to that. So this was more of a consumer-driven concept. So that's why it was included. But I do understand what your argument is, that it does say prior to the completion of the sale.
Well, and Mr. Perkins, I don't know, because I haven't been out in the field a whole lot the past few years.
What have you been doing?
I know, on runs. I agree with what you're saying, because prior to the actual negotiation, I, as the consumer, may not know exactly which vehicle I'm asking for.
Oh,
Steve,
absolutely.
could you please find me a BMW, either black or red, this year? You know, it's going to be very hard to fill in some of this
You can't.
information.
It's impossible.
You know,
And if somebody comes in and says, before I can talk to you, I need your full legal name, oh my God, sometimes they don't even want to tell us their name. Or they give us the wrong name until they're comfortable with who we are. Yeah,
Isn't
so
that-
somebody,
isn't that
exactly.
currently what
Somebody
happens
says,
a lot?
yeah, you might, I want a 2018 BMW, and we scour the country for it, and we find one in Timbuktu. And then at the 11th hour, you go, well, at that monthly payment, why don't I just get a new one?
Exactly.
Okay, great. Well, we've already started negotiation, but now,
Now we're shifting gears.
yeah.
So it sounds like we'll change the language in Part A to shall, prior to the completion of the sale, exchange, or lease of a motor vehicle not owned by the licensee. We'll handle it with the language. Provide to the consumer for his or her review and signature, and then the rest will stay the same. So we'll change, again, shall, comma, prior to the completion of the sale, exchange, or lease of a motor vehicle, provide to the consumer. And then it kind of continues on from that. And then, Mr. Perkins, in response to your point about including the statutory language in the regulation, the reasoning kind of behind that was that we wanted to make it clear that if a dealer comes in and makes a copy of this, exactly why it's being required. We just thought it was a little bit better to be a little bit more specific for purposes of informing the consumer as well as the dealer what the requirements are. I'll leave it up to the division because I don't.
Certainly, the form is not mandated. We can put this language anywhere we want.
Yeah.
Right?
Yeah.
So certainly we could, pursuant to Colorado law, sections blah, 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 someplace else.
Sure.
Right? And certainly my current disclosure speaks to the old, pursuant to Colorado law. Right? Nobody wants to know the statute or the regulation. They're not. Really, they go, what are these numbers? My salespeople won't even know what they are. Right? What is that? CRS. What is CCR? No, they're not supposed to know the actual statute or regulation. I'm sorry.
Yeah, I'd be blown away.
Yeah, well, maybe not the number, but.
Well, yes, that's why I'm referencing it. It just is, what are these numbers? So that would be a request of mine too, that we just call it pursuant to Colorado law. Does it not get to the same end?
Yes.
Yeah, I think so.
Yeah.
Okay.
I want to go back and have a not debate, but I want the new car industry to sort of weigh into it, Todd, because as I walk out the door, I mean, walk in the door and now I walk out in the years I've been here, I always thought that it was our job to ensure fundamental fairness any place we could. And we were going to make a little bit of an error, if that's the right word, we always err on the side of the consumer. I mean, that's sort of, we are slightly more than the other way, the Consumer Protection Agency. So does this compensation, this new form with the change in the law that it's at the completion, does this new form ensure consumer protection? And it is our job to regulate, but it's also our job not to overregulate. And so I want to talk about the burden of where this form goes after the consumer looks at it and signs it and understands, how, in your case, how you got paid. So you keep this in your deal jacket.
Absolutely.
But you buy you facilitate the sale of a new car in a Ford dealership.
Right.
So the Ford dealership then, ABC Ford, then does all of it's all on their paperwork, you're facilitating that unless you buy it from them and take title.
Sell it as a used car.
They sell it as a used car,
Right.
but the ones you sell the ones you facilitate as the sale of a new car is on the Ford dealership's paperwork.
Right.
Okay, but this form, because I'm your customer, I'm dealing with you.
Right.
You do this form for me.
Right.
Do you do this form for the Ford dealership?
No.
Does the Ford dealership feel that they need to have this form for consumer protection? I mean, that's the question, is because in that particular case that I just said, that consumer, Bruce Suloff, I went to Steve, 'cause I've known him for years, and I want to deal with him on the sale of a new car. He's going to facilitate it for me. But in reality, I'm buying that car from the Ford dealership.
Right.
Sort of in reality.
Right.
Does the Ford dealership need to protect me? Because you have. With this, does the Ford dealership need to protect me?
That's amazing. I'm not immediately familiar with that form. It's not one that we sell or not one that I've seen before, but it seems like you're drawing the lines between joint and several liability if there is an issue. So I would think that it would protect Steve in this case.
And the one part of your hypothetical or situation that you described, which is that the Ford dealership is selling it directly to the consumer. I think what Steve described his practice is they take title and then sell it to the
No, they're
consumer.
both of those, Michael.
Okay,
Both
so
types
you
of
do, you
transactions.
facilitate direct sales.
Yes.
Well, and the important part from the consumer stake protection standpoint, and I think the whole reason this regulation was adopted is to let the consumer know that if that person they're dealing with is getting paid by both sides of the transaction. And that's the boxes that were created by Leland and Brad to say, mark each box that applies. So if that middleman is collecting money from both the consumer and the true seller of the vehicle, that's what the consumer's entitled to know. That's what's designed to protect them with knowledge of, yeah, I'm in between two people who are both making money. You know, or this person is making money off both of them.
Right.
So-
That's really that is truly the triggering when the consumer is also paying, i.e. the buyer's agent, right? He can't receive compensation from of course, the owner of the motor vehicle.
Right.
But to create that I'm getting paid on both sides. Yeah, and that's why both boxes are in there.
And so from the consumer standpoint, Bruce, I think that protects, in terms of protecting the new motor vehicle dealer, their paperwork is going to protect them. I mean, if it's a direct sale facilitated by an individual or a company, you know, their paperwork is presumably going to protect them. I don't know that they need a copy of this in their file. This is all, you know, signed by the ultimate consumer, and it explains to the consumer, you know, who they're getting paid by, who's getting money out of this deal. Although if you're Mr. Perkins, you don't like to make money, you just like to sell cars.
Yes.
Well, certainly, I mean, certainly when we have the internal staff, we were talking about the consumer protection and all of that, but then you get into this thing, are we over-regulating? And so
Right.
if this form is a requirement, this form or something like a requirement for you, Mr. Perkins, and you have this in your deal jacket when we come and look, because we're looking for something in some complaint or something, but we go to the Ford dealership and now this is not in their deal jacket, but all of the sales documents are in their jacket. Are we gonna hold the Ford dealer responsible because there's a violation of this regulation? That seems like that's over-regulation to me. But at the same time, we have to think about consumer protection, so it's this balancing thing.
Right.
Consumer protection, regulation, over-regulation. I don't have an answer, I'm really raising the question.
Well, and I will tell you, of the deal jackets that I have seen that are at the Ford dealership, it usually says on the outside of their deal jacket, money went to Centennial.
Absolutely.
Or, you know, there's usually a trail of breadcrumbs there.
Yes.
In this instance, if Mr. Perkins is providing it to his customer that he's facilitating this through, we've met the notifying the customer, so maybe it doesn't make sense to have it in the franchise Ford dealer's jacket. I don't know. You know,
It's a regulation to me of a used motor vehicle dealer, and now you're trying to put that regulation on the owner of the new motor vehicle dealer, and it's, and I'm about consumer protectionist, so that's not, yeah.
Well, it seems to me that when a consumer buys the vehicle at X price, they know what the price is, they know what they're paying from this form, so why would the new car store in this example really have any consumer protection issues at all? I mean, why would the consumer have any issues with the new car store? They're buying it for 30 grand and they're paying this fee. I don't see where there's any lack of consumer protection if the new car store doesn't, or the owner doesn't have the form. It doesn't do any harm to the consumer that I can envision.
Todd and Steve especially, the two of you, are you comfortable with the additional information that is on the new form?
Yeah, I went off the old regulation and and I'm surprised because it's just reprogramming to plug in the year, make, model, and VIN. So it's not, that's an easy, and then there's no question on what the transaction is about versus a blank one.
And we sell our forms by profit by the number of lines, so.
I don't know this. This requirement, the current regulation, the requirement for this language, you've developed your own form?
And incorporated all of this into it, yes.
But is there a form out there, does the forms people, did they develop a form that they sell for this particular?
Yes, we have our version of it.
Okay.
But it's not a DR.
It's not a DR.
It's
No,
a CIA.
There's not a DR.
Okay.
The Bradford Publishing Companies have one?
No.
We do not.
There are some states out there, California, which of course mandates the purchase agreement that all dealers must use. And they do within their form have a broker disclosure box that says that a broker is being paid compensation as a result of this transaction. Or maybe we're becoming Californicated.
I'm not touching that. You're the one that said that.
So, Mr. Perkins, is what you're suggesting is that in 1B, that the last line not be here?
And say that to me again.
In the proposed revised rule, in 1B, the last line, if that
Yes.
was removed from there,
Yes.
you wouldn't have any issue?
No. Well, other than at the conclusion of the negotiation.
Yeah, we already took
prior
care of
to the
A. I'm
completion,
just on
right.
B. So on B, the only
Right.
thing that needs to be changed, in your opinion, would be just that last line be removed?
Yeah,
We'd have to remove part of the prior line. So for example, it says, shall at the conclusion of the negotiation retain the original and completed and fully executed compensation disclosure document and its records related to the subject vehicle, and shall also provide a copy of that document to the consumer, period.
Mhm.
right,
That would change.
right.
And then like Chris said, then that final line would go.
Mhm.
Okay.
Todd, are you okay with that?
Yes.
And Mike and Matthew, from the standpoint of that uniqueness of the facilitation? In the form itself, at least all the boxes, all the line, everybody's comfortable with that?
Except changing pursuant to, and the section of regulation, we'll change it to pursuant to Colorado law. And we'll take out the middle part where it says provided in or any manufacturer dealer is a dealer. We'll take that out and then just put in brackets after dealer license number on the right-hand side, if applicable.
Right.
And,
At
you
the
know,
very
looking at
bottom,
the-
is that what you were talking about, you were gonna clean up about the owner copy?
That's a good point, we missed that one.
Oh, on the bottom of that?
Yes, the
Yeah.
bold down at the bottom.
Yeah, we'd have to do that too.
Right. And does it have to have the printed name of authorized representative of negotiating used motor vehicle dealer? Is not just used motor vehicle dealer sufficient?
No, the reason, this was really, people pointed out that, it wasn't clear, if this is a car from a used dealer versus a negotiating. The idea was to make sure that we could differentiate the real parties. in the document. That was the whole point.
But the statute identifies the party as a used motor vehicle.
Okay.
What was the question? I'm not understanding.
Oh, in the form, it talks about the signature of authorized representative of negotiating motor vehicle dealer. Well, if that doesn't comport to the statute, and we're talking about prior to the completion, we just take out of negotiating, just the signature of authorized representative of the used motor vehicle dealer.
You're recommending taking that entire line out?
Just of negotiating.
Just take
Of
out
negotiating, just the words. Got it.
So you're not saying we need to get rid of the signature line?
No.
Oh, okay. Just
No.
that, I think that's where the confusion is.
Yeah, that was what I thought you were
I'm sorry,
saying.
no, we want the signature. Although, in looking at it closely, in the original regulation, there is no signature portion in that regulation.
I can't imagine why there shouldn't be, but,
Well, it was just authorized dealer signature.
yeah.
Not the consumer signature.
Well, the consumer signature's right below that.
Oh, I didn't read the second page, you're correct. It was, I stand correct.
No problem.
Okay, so are we clear on the changes that we're looking at on this?
Yes, I have got
Notice what I'm
a
looking right
working
at.
document regarding it.
Thank you, Mr. Jones.
And then the power sports would be the same?
Yeah.
Comfort level with that one, moving forward, okay?
Okay.
How about, it's 3:12, how about we break until 3:30? About 15 minutes, correct? Josh, you should, so for the record, we are breaking. Okay, we're back on the record, time is 3:26, and I think we are now moving forward to rule set 4. Okay, all yours.
All righty. This has been labeled topically as licensee self-reporting criminal conviction. Okay, introductory comments on this. There's 4 rules in this set, parallel motor vehicle and power sports versions of both a salesperson related and a licensee other than salesperson related rule. Okay, the motor vehicle statutes related to the current rules came into existence in 1984. The motor vehicle rules related to those statutes came into being thereafter, but significantly prior to the General Assembly adding what we have always referred to as the mandatory disqualifying statutes to the statutory scheme. Significantly, as currently in existence, the reporting requirements tracks the substantive language solely of the statutes prior to the incorporation of the mandatory disqualifying statute. And I'll get more into that in a minute. A staff review of the existing rules brought out that there was no principal basis to exclude any serious crime from the reporting requirement. Now, just thinking about this, look at an application process. When we begin the story of an applicant, okay, we are going to expect a certain amount of disclosure right up front of felonies and misdemeanors. We give them time periods, things like that, that they're going to have to meet those criteria. We also fingerprint them, and we do our own record checks based on the fingerprints and also based on the other databases that we look at. So we end up evaluating their fitness, if you will, to have a license based upon sometimes a number of different criminal violations of record. Among those might be very serious ones that the legislature has basically said will mandate denial of the application, or later will mandate a revocation of that license. Then there are others that are sort of halfway in between the really serious and the very similar to the same serious ones that have their own separate section. And we have a whole bunch that would fall under what we would consider to be, in fact, every one of them would be under a criteria that we call, unfitness of criminal case. Why does all this matter? There are very serious offenses out there that are, even in this state, not going to fall under the mandatory disqualifying felonies. We might have certain types of drug convictions, things like that, for example. We might have others that in other states get labeled very differently from ours, and they might be considered a misdemeanor in Florida, and they translate back here to a serious felony. Okay, so what our staff felt in general is that anything that is, important as a criminal, conviction should be reported on application for sure. But likewise, if we are expecting it on the applications, we certainly expect the same kind of attention to be paid by licensees to report in if they get that kind of violation later. That's the concept. So that's why no principle basis to exclude any serious crime from the reporting requirement. Okay, then also the staff review considered any revision to these rules should be consistent with other provisions of law and regulation in order to avoid any confusion or defeat appropriate enforcement. So, therefore, what happened is that these current proposed revisions seek to clarify a few points. A, and that it is always a licensee who is responsible to report a criminal case. If you're a salesperson, then that's you. But if you're an entity, well, rarely do entities get convicted of a crime themselves, but their owner might, or some other person who's in a responsible position might. So that means that the licensee may be reporting his or her own criminal case or that of another specified individual in the licensee's business operation. But it's always the licensee's responsibility. Okay, the third point, the notice of the criminal case is in writing. Well, obviously, that's how we have to do it. Then, that there's a strict time frame within which the criminal case must be reported.
Yeah, you're absolutely
Now,
right.
it could be really strict, as other agencies within the Department of Revenue have, as in, you got it today, you report it tomorrow, because it's immediate reporting. Or it could be really loose, like, hey, 6 months from now, let us know. Okay. Owing to the need to have some definitive time, we settled on what we settled on this time. Okay. Then also there had to be a defined range of reportable criminal cases. Okay. So maybe we don't want to have, in fact we know we don't want to have, the little old, speeding ticket. Because we don't care about that when we do the application to begin with. So we're not going to care about that on a reporting requirement. And then lastly, that certain certified documents be provided with the notice so that we have available material on which to act immediately, if immediate action is needed. Okay, so now the staff was concerned that the revisions capture all the criminal cases significant enough to report taking into account the expanded levels of concern that the General Assembly addressed by adding the mandatory disqualifying felony provisions. Notably, the proposed provisions do capture almost all the types of criminal cases important to get enough, but after the drafts were done, it was discovered that a significant portion of the mandatory disqualifying statutes was not yet covered. We apologize. It probably should be. Because what we're talking about is some really explicit language that is extremely targeted to this very industry and extremely important. So I'm talking about here the potential to add to our current set of qualified criminal statutes language that would cover specifically section 4420-121, parent 7, parent A, parent 2, where it refers to a crime involving odometer fraud, salvage fraud, motor vehicle title fraud, or the defrauding of a retail consumer in a motor vehicle sale or lease transaction. Yes, we know that in many cases, things in that set would be captured by language we're proposing of, quote, felony nature, but not always, and that's the problem. If Kansas violation looks like a misdemeanor of a motor vehicle sale or lease transaction defrauding, well, maybe it wouldn't have to be reported under the current language as we've set it up in this new proposed rule. Whereas if we add those categories, we know we can then ensure that somebody is at least attentive to the fact that anywhere they get a, violation like that, that they need to report it. So that I'm just pitching because we haven't as a group discussed that. But we did discuss the need to have all of these important things in it. We just didn't get the language in to cover that. Brad, do you have anything to add?
I don't think I have anything to add to this one. Well, actually I do. The one change was that we combined it, two existing regulations, one that applies to used motor vehicle dealers, wholesalers. That's under part 3 of the regulation that is titled 4421.21.3C. And we also combined the one with motor vehicle salesperson. We put that under the regulation 4421.21 because that's kind of a catch-all under this current naming convention. And that means that it would apply to all license, and I think we're gonna have to put this in there, that are issued by the motor vehicle dealer board.
Yeah.
So we'll clarify that. But that would include motor vehicle dealers, used motor vehicle dealers, wholesalers, salespersons, and the new license business disposal. Part of this was a confusion. In my experience, there's been some owners of motor vehicle dealers that thought there was only a provision that applied to the salespeople, because that's the one that we most frequently see. And I know Mr. Perkins is agreeing with me due to his time on the board. So we wanted to make it clear that it applies to all licenses that are issued by the motor vehicle dealer board, and just make it a single regulation. Again, going back to some comments that Mr. Beebe made about 2 hours ago, this is in preparation for efforts of recodifying the naming convention for the entire regulations and going to more of a topical approach. And this is how most of the other state agencies would kind of approach a similar regulation applying to a number of different licenses. So.
And to Mr. Beebe's point, what you said about the odometer violation is a very good catch on your part, because the way that this is currently written, it's talking about any felony, right? Which oftentimes, which we just recently saw with a Colorado dealer, it ends up being a misdemeanor. And the odometer law is in 42.6, Part 2. So it doesn't fall under Title 18. So I think that's an excellent catch on your part, Mr. Beebe. I think we do need to put that in there.
I know everyone is not asleep. Okay. I just gotta ask directly, okay? CADA, CIADA, with regard to the reporting requirements that this will place on dealers, is this an issue to you in any way, to your community?
No.
Okay.
I don't know if I'm understanding 1B properly. I get that we're saying if salesperson has a disqualifying conviction that his dealer's required to report it, and I'm good with that. Where it says the ability to control licensee or exert significant financial or operational influence over the licensee, would that stop like a debt collector as holding this over somebody's head? You know, come back and pay me $5,000, I'm going to the board and taking your license away? Because I can very well see that happening.
Okay, this is a very good question because it brings out something that we attempted to do here and would attempt to do elsewhere where needed. Okay, in the last couple of years in rulemaking, okay, we examined in the application process who it mattered to receive information from and about. Okay? And so we looked at specific regulation here for applications, for all applications. Regulation 4420-104, parent 3, parent H. And in that regulation, we require, as part of the application process, the receipt of information of significance, whatever that might be, whether it's the financial information, the criminal information, we require fingerprints, from those individuals who, here in paragraph 3 of that regulation, it tracks the language exactly here. So that the 3B of the regulation we passed a year ago says an ability to control the applicant or to exercise significant financial or operational influence over the applicant. So that was the discussion a year ago on the application side. And so to be consistent with what we would ask for on the application side, we would have to expect the same individuals in those statuses to be telling the licensee, owner, whoever, about their circumstance so that he or she can report that to the board. So, you know, the discussion was a pretty full discussion on what that meant and didn't mean. And, you know, things came up about, what about my wife? Or, you know, I mean, certain things in a frivolous way tried to ferret out what would or would not matter. And I think part of the conclusion out of that discussion was an enforcement-related view that, you know, realistically, there are a lot of things that would never be considered that important. Or in, you know, but if we don't see that people do it, we won't get the information to make that determination. And we had some, you've given another hypothetical. We had some others that were equally out there. And those couldn't possibly be part of this regulation in its actual enforcement. But, you know, what if somebody is a non-licensed individual like a controller who is functioning under very strict federal and state guidelines and accounting guidelines? And that individual gets a mandatory disqualifying felony and is sitting right in the heart of the organization in a really significant role. Well, that might be an issue. That one might be an issue. You know, I don't know whether that's the time that somebody like Mike picks up the phone and calls somebody like Chris and says, what do you think? You know, because these are, you know, we're talking about individuals who could steer an organization to a wrong place.
And Leland, my problem with how broadly you drafted that language, it could apply, it could apply to, let's say, a floor plan lender who's convicted of a crime, and all of a sudden now you've got an obligation to report that your floor plan lender was convicted of a felony in Florida. Everybody's getting convicted in Florida in these hypotheticals, so I'll use that one. You know, and so that's an entity that has the ability to exercise significant financial control or operational influence over a dealer.
Absolutely.
So it's a pretty broad net you're casting there, Leland.
But they're not inside.
No, they're not.
And that's one of the things that we talked about too, was the difference between the outside influencer and the inside influencer. And the outside influencer, the wife example, you know, obviously that does not make sense. You know, if she's the equal partner, well, yeah, okay, that makes sense. So the floor planner, an outside entity, has their own problem, and it translates to a problem for your dealer. Well, yeah, that's a consequence, but it doesn't sound like a reportable event.
Well, and I think that that's what you were trying to capture at the beginning, was it not, Mr. Beebe? Where you have who is associated with a license.
Yes.
Licensee with any other class of license.
Right.
So a floor planner is not a licensee in any way, shape, or form. We don't regulate them. So I think to Mr. Dommermuth's point, I don't think that those would ever be reported because they're not a licensee also.
No.
So I don't think we're putting the burden on a licensee to report a non-licensee that they're affiliated with, right?
Right.
Is that
Yeah, I think that's right.
Is that how you intended when you wrote it? Because that's what I get from it when I read it, is that they wouldn't have a duty, nor would they probably have any knowledge that somebody from the floor planner got convicted of something. But I don't think they'd have a duty under this to report that because they're not a licensee under them. A prerequisite relationship does not exist in our system with them.
Yeah, we wouldn't have put them in an application context. I mean, if they wouldn't fit in an application context as someone that we would be asking for information from for a dealership's application, then it wouldn't make any sense that they would later have to report unless they'd entered into that.
Well, the controller example you used, that person is
not
part of the
licensed.
application
That's
process.
true.
That's true, they're not licensed.
That's true.
Let's go a little step forward that happens
That's
in a
true.
bigger dealership. Your compliance officer, whatever you call it, doesn't have interaction with consumers generally. It's just an OHR person. They do exercise, both of those can exercise operational influence, both an OHR director and a compliance officer or whatever. So I do think that that's a possibility. We're a little too broad there, a little too open.
Instead of associated, could we say employed with, employed by?
Well, there's business models of that where the employed word is not applicable.
Right.
Associated is applicable.
Well, and to throw a wrench in it, we have this business disposer license where none of the employees are licensed.
Yeah.
Yes. Oh. Oh. Well, yeah, this is brand, John has just put us in new territory.
That's the elephant in the room.
Right.
Yeah.
Thanks, John.
Because we could have a publicly traded company that somebody's got to be that natural person who is running the show. And if that person ends up being convicted of one of these, should that put their license in jeopardy? And I would understand that the legislature, that would be their intent for having that statute, but I wasn't involved in this legislative portion.
So I guess my question is, how much of a problem is this? We're making the regulation broader. It seems like that would be reactive to a problem. What kind of problem are we talking about?
What we don't know. Okay, I mean,
But doesn't that seem like you have to have a justification to broaden the regulation, and right now your justification is speculation?
Well, I can answer that. Within the last 5 years, I've had as many as 8 or 10 phone calls from individuals who refused to give me names, but who had lots of information from the inside of the dealerships. And they specifically talked about people who had not reported violations. And these were not just sales guys. And so I think the answer is we may not have ever gotten to the case. And I fear that the reason we might never have gotten to the case is the fact that people honestly didn't think they had to. I'd like to believe that, but they just didn't think they had to report it because after all, you know, I'm just a partner. I'm not a sales guy. And, you know, the fact is we want to know that information if it's true.
But with respect, there's no ends to the information the government wants. That's why we have a Zettabyte Center in Utah. But I mean, you're saying the wife situation could never happen, but I imagine it's the situation with a lot of Todd's dealers that the dealer principal is your husband or your brother. Or dad's getting ready to retire and two siblings both want the dealership and they're trying to rat each other out. We've actually had that situation.
So that seems like a reason to broaden it.
Yeah.
No, he was saying the trite personal stuff can't come and impact your license, but in those situations it seems like it could.
So if the comptroller, who has significant influence over the ownership, but is not a licensed person, and never even gets close to the definition of a salesperson, but issues significant control, the comptroller gets convicted of a mandatory disqualifying conviction. Do we want to know that? And if we know that, what are we going to do with it?
Yeah, because they're not a licensee.
That's
So-
Statutory authority to know
Yeah.
that.
They're
It
not
would seem that you
licensee.
guys would want to know that more than we would in that
Right.
scenario.
Yeah. Yeah. It almost, it to me raises the question of, do we have enough licensees, enough categories of license? Because other, you know, agencies in our department are much better at licensing than we are. And, you know, you can look at gaming, you can look at racing, and you quickly see that they've tried to capture all of the significant parties that could be involved in the transactions that matter to control, to prevent crime.
And they get hammered all the time that they're overreaching.
Yeah,
All
well,
the time.
and they did it.
Well, we don't want any more classes of licenses.
No, I'm just saying that's.
But I gotta tell you, Chris and I can speak of this, and Mike can probably speak to this too. We see proposed legislation every year to go the opposite way.
Yes, sure.
Now, some of it has passed, collateral consequences passed. Some of it has passed, but we see it every year, and I guarantee you all will see it again this year. Because the issue is we need to put more people to work.
Yeah.
What I don't want to do, as I walk out the door, I don't want to see something, I don't want to see a conviction that really matters, be overlooked, that a consumer walks in and is dealing with somebody that has been convicted of a very serious matter that's going to take their personal identifying information and could compromise that because of that. That's what I don't want to see. But I don't know that a comptroller fits that. I don't know that an OHR person fits that. I don't know that a compliance officer fits that.
I mean, by virtue of the fact that we don't contest A, ownership, financial equity interest, wouldn't the boss have to know if there was a felony conviction? Wouldn't you be missing days of work to appear in court? And wouldn't that eventually trigger questions? Where are you?
It's a good theory.
And he may not care.
If you're selling 100 cars a month, you bet we don't.
Yeah.
Oh, but at the same point, by virtue of not contesting A, if the owner does know and doesn't say anything, then it's on him as well, right? And that's not only action against the mandatory disqualifying for the salesperson, that's action for a violation against the dealer license as well.
Right.
But
In that
these
circumstance.
mid-management employees who don't know where they stand and don't want to lose their own jobs for, whistleblowing, what have you, I think those are the people that concern us.
Yeah. If they're not licensed, probably they're not going to fall in this.
Well, they're never in trouble with you guys. But
Right.
if you rat out 100 sales a car, 100 car a month person, then they might face retribution from the inside. And I think that's where protection would be warranted.
So Matthew, what would you propose, what changes would you propose to the group?
I mean, I'd be inclined to strike B and leave A. What do you think?
Yeah, I think that's, and let me give you just a concrete example from just a few years ago. A publicly traded auto dealership group in Colorado, who operates stores in Colorado, had one of their stores arrested criminally in Southern California a few years ago. It was the Chevrolet store there. I don't know the outcome. I don't know if that store itself was ever convicted, but this regulation would require that group to come in and say, hey, one of our stores was convicted of a crime in California. And I'm not sure that's within the purview of what we should be doing here.
Was this like a criminal enterprise conviction?
I think it was just a dirty dealership that was, and the California Attorney General came after him really hard. I think there were some individual convictions. I don't know if the store itself, I know the store itself was indicted, but I don't know if it was ever convicted.
Well, that's really interesting hypothetical. If an individual within the complex of the store was also convicted, the individual would certainly have to continue the responsibility.
It's a person's license,
Yeah.
right?
But if the store, an entity, was convicted, there had to be, as part of its operation, responsible individuals, and we might, under a different theory, go after those individuals. I mean, we might, because there is a corporate responsibility doctrine in Colorado. Hard to, Brad, did you want to?
Well, I think you all raised some very, very good points. I think taking a step back at it from it and looking at it again, hearing your comments definitely makes me view this from a different angle. We try to include with any other class of license issued by the board language to kind of narrow it down. But from what I'm understanding, what you're looking for is it to be more tailored. So salesperson is the most obvious,
right? Because
they have to hold a license. But for motor vehicle dealer, used motor vehicle dealer, if they're acting in a no-fee owner capacity, they would be the ones that would be the most concerning to this. Is that my understanding?
Wait, can you say that again?
So, with respect to a motor vehicle dealer, a new car motor vehicle dealer and a used car dealer, we're looking at subsection 5 of 442121, and that kind of closely ties it to a no fee owner status. Is that what you're looking for? Something that ties them specifically involved with the business, or are you just ownership in general?
Well, ownership as it pertains to subsection A, I don't have a problem with, right?
Okay.
If you're a dealer, you're licensed, you're covered. If you're a salesperson, you're licensed, you're covered. If you operate a business, you're still licensed with the Secretary of State's office. You still have an
Yeah.
obligation to the state. It's all those people that don't have an
Okay.
obligation to the state.
Okay.
And to Matthew's point, I think the no-fee owners are a licensee. We just don't charge them a fee for it. They're still an owner.
No, I get
So
it.
I believe,
Yeah.
I agree with
They're still
him with the, they fit into A. They're
Yes.
still a licensee.
And I just want to make sure that we understand the scope.
Yeah.
So all you're looking for is to eliminate subsection B, so it's clear that they have to have some ownership interest in any type of these licenses that are issued by the board.
And that gives the middle management person the ability to, I guess, take it to the owner rather than take it to the state.
And doesn't put the onus on the owner then to report that person to the state,
I think so.
since they're not a licensee.
If the controller's not licensed, and he's the floor planner, he's the money, and he's exercising the privileges of a dealer, and he can't get a license, or he's just been convicted, and he has influence, but
What we would do in that situation, we would investigate the dealer for is this person, are you allowing this person to exercise a right
Right.
and privilege that this person doesn't hold? And I think we can do that.
okay.
What I am really concerned about, you know, we touched 22,000 licenses last year, 22,000. We have a hard enough time regulating our licensees with fundamental fairness. I sure as hell wouldn't want this division to take on trying to regulate unlicensed people.
Or investigate them, or.
Planners.
I can't.
I mean, it seems to me, and I don't, this probably is outside the scope, in the military, we had this issue of sexual assault, right? And you never wanted to take it to commander because there'd be retribution. So they established a SAP or a 2-star or somewhere along the lines of commanding general on the base that you had a direct line to, and they could do their investigation. If they deemed it necessary, then they could report it to the JAG. So you gave them a duty to at least investigate, regardless of whether or not they reported. And if they found merit and they didn't report, then they did have a duty, and there were generals removed because of that. There's an investigative burden, it's just not yours.
So, Matthew, Mike, and Steve, Todd, if B is removed, is the rest solid? You know, if B is removed, do we compromise?
This isn't the perfect world.
I mean, this is one that, when Chris and I talked about this several weeks ago, we wondered about whether or not this was really broken or not, okay? And I do think that what was being proposed here, I not necessarily don't think it was broken, but what is being proposed here may be a little clearer, but I certainly understand the concerns with B, I really do, because now after a couple of examples, that I'm thinking, well, yeah, how in the world would we investigate that? And under what authority? B, so. But the rest of it seems to clarify, maybe better than the existing rules, so.
Well, this is also just a reporting requirement. It doesn't mean we can't still investigate this stuff when it comes to light. It just doesn't put that reporting burden on.
True.
Yeah, I don't think we're letting anything slip through a net by removing B. Because like John said, we still, if we get the complaint that somebody has been convicted of something and they have some sort of, we can still look at they may not be a licensee, but are they acting in the capacity, being allowed to exercise a privilege, all of that good stuff, so.
And I think you guys have seen a couple times, even when people aren't comfortable reporting, they call me and I report it.
Then there'd be the additional language that we put in to deal with the other mandatory disqualifying felony types of convictions that we talked about. Is there any
The odometer.
The odometer fraud and all that.
None. I mean, not for me.
I think everybody might want to know about that.
Yeah.
Yeah.
Do we have more self-reporting, or do we have somebody dropping a dime on somebody? And that's how we find out about it.
I would say it's about 50-50. A lot of people will report. Some don't report in a timely manner. They wait until they renew. But you know that's, they do eventually report. But the other 50% is usually ex-wives, ex-girlfriends, ex-whatevers that want to, make somebody's life miserable.
Boy, you're chill.
It's the truth.
So the other thing I'd suggest is have an intro that says this regulation only applies to license issued under Part 1 by the board, just so it's clear from the PTO rules regarding manufacturers. So
Yeah. Where would that be? At the very beginning?
right at the beginning.
So what paragraph, Leland, would we add just that little bit, a little bit additional language about what the statute says about fraud and odometer stuff? Would that be in paragraph 2? So that's not going outside, that's just adding some stuff that's already in the statute.
Yeah.
Is that
Literally
correct?
using the same words.
So, ladies and gentlemen, if we make those changes, is everybody comfortable with that? The method in my madness is try to get to some kind of a general consensus that we don't have to come back for a second meeting. I mean, I'm just being totally honest here, so. Can always still be debated at hearing.
Right.
But is there a need for another full-blown kind of stakeholder meeting if we're making these minor changes? And they're going to be sent out to you.
Right, that's what I was just gonna say, like normal, we get a revised copy.
Yeah.
And then if you had a small technical issue, it wouldn't necessarily have to come back for a full stakeholder meeting. You could just make a notation of that, and that would go into the board's packet. And the ability at hearing to say, can we add this word or subtract this word or this word?
We have a fairly rigid timeline in order to make sure this hits the October meeting as the rulemaking hearing. So, there won't be a long gap for anyone to forget this discussion between now and when, the rules go up in the notice of rulemaking, so.
Okay.
Alrighty.
Rule set 5?
Yep, ready to go. Okay, topic being issuing, reissuing, and posting of licenses. Now, any of you that were observant, and I imagine everyone was, in my original set of materials out to you, the topic was slightly different. Well, that's because, you know what, this grew. And, okay, so this is both a motor vehicle and power sports rule of identical nature. Okay, the division has identified another set of rules closely related to the two on the current regulatory agenda. Specifically, these are sections 44-20-110, the rule that goes with that, not the section, it's a regulation number, and regulation number 44-20-410 in the power sports side. We treated those rules last year. And these offer an opportunity for us to achieve a better amalgamated rule if the current rules on the agenda are merged into the 2 noted rules that will have to be added to the agenda. Now, all of this points to why topics matter. Because we took up something last year that was a very minor piece of a bigger topic, the piece of posting a license. And really the topic is the whole licensing issue, reissue, posting process. It's a package. And so now we're looking at something that is the other part of that package, or another part of the package, and thinking, well, we might just as well get it all together. So what is at issue in these rules is a license issuing, reissuing, and posting procedure for licenses, in particular for salesperson licenses, that currently does not exist in a single convenient place, but rather exists partly in 2 separate rules, partly in a statute, and largely in office policy and procedure. And I need to point out to you that no office policy and procedure exists in a vacuum. Obviously, it's all reflective of an understanding the division has had over many years of the best way to practice a given thing. Okay? The spread out nature of this rather straightforward procedure has resulted in a mixed compliance with the process. This is the important point. We haven't had universally good compliance with each of these aspects, and we hit this every day at the front desk or somewhere else in our licensing system. And we hit it in many ways. We hit it because dealers are not doing something, or salespersons are not doing something, or they're both not doing something, and we have to pick up the pieces at the front desk and go out, send them out to do something. We might have to reject something and hold something and continue a process that could be done right the first time. So in theory, packaging something up might give notice to everybody, hey guys, this is what you do. Don't worry about all that old stuff, do it right now. Okay, so it is to the detriment of salespeople, to the detriment of dealerships, and it's avoidable frictional cost for us to keep things as they are. So for the benefit of discussion, let me just read you something that is kind of interesting when you get to it, which is the motor vehicle version of a statute I just referred to as part of this record. Okay, the statute goes back clear to the year 2000. It's statute section 4420.119, of which paragraph 3 reads, I hope this isn't news to anybody. If a motor vehicle salesperson is discharged, leaves an employer, or changes the place of employment, the motor vehicle dealer or used motor vehicle dealer who last employed the salesperson shall confiscate and return such salesperson's license to the board. How often does that happen? Well, for some dealerships, it's all the time. For a lot of dealerships, it's never. Okay, upon being reemployed as a motor vehicle salesperson, the motor vehicle salesperson shall notify the board. Well, yeah, he kind of has to because he has no license. Okay, upon receiving such notification, the board shall issue a new license for the unexpired portion of such returned license after collecting a fee set pursuant to blah, blah, blah. Okay, that's the so-called reissue during the license period. So what really happens? They come in the door, let's say, and they say, I've just left over there and I want to start over here and I've got this deal all set up, and our front desk people say, okay, there's a form. There is a form. They may not have that form because that form was attached to what? The license that was sent to the dealership back when. Well, why was it sent to the dealership? Because that was a compromise long ago as part of the let's have this sort of wedded license thing between the dealer and the salesperson. So the dealers accepted that responsibility of receiving that license, the salespersons probably had no voice, but we would pretend they did, said, okay, fine, that works. So the license ends up at the dealership. Well, one piece of it, the very top third, is supposed to go wherever the posting will take place. What happens to the other part? The part that's going to help that licensed salesperson later to do what? Transfer to another place. If he doesn't have that part, what do you think happens here?
Starts over.
Well, it does. It sort of does.
We repeat.
But we charge him to get started. We charge him for what he didn't get from the dealership. Because what are you going to do? Chase it down, call the old dealership and say, what happened to that? Well, I don't know. That's 4 HRs ago. I mean, I don't know. So the point is, we just constantly are doing this, and it's happening either on paper every day when they just send things in that aren't complete, or it's happening at the front desk. And in any event, something has to happen that shouldn't have to happen. So staff recognized also that there's another issue. There's a funny little thing called a bond. And believe it or not, salesperson bonds are still salesperson bonds, and they're issued for 1 year. So you go to work for dealer A, he maybe bought that bond for you to work for him. And you leave. Well, where's your bond go? Does dealer A hand you your bond so he can come up here and say, oh, here's my bond, so let's get this license transfer process complete? No, it doesn't happen that way. What often happens, in fact happens en masse in some cases with some dealerships, they cancel the bonds. They terminate the bonds the minute the salesperson is gone, because they can recoup something, a piece out of what they paid originally. So where's the salesperson that comes in the door? No bond. He's got to have a bond. The law says he has to have a bond. Absolutely says he has to have a bond. So whose job is it to make sure he has the bond? Well, he may never have bought a bond before. The dealer did. He may not have a clue what to do to get one. He probably doesn't know he doesn't have one. And we don't have the staff to follow all of these avenues up. It's a very big issue if we had to do that. So this new formulation here places the responsibility, the only place we know to right now, back on the sales guy. They're the ones that are supposed to be paying attention to their bond. We can say, yeah, you have that bond, better get that bond. But, you know, that's where it's at. There's never been that push as part of a package rule. And so now that's in this new package rule. So you can tell that was kind of one that I got kind of upset about. Turns out we don't have many cases of violations of salespeople bonds. But the law is still the law. Okay, so at this point, I guess I should turn it over to Brad. Brad, do you have anything to add to this one?
No.
Okay.
I'll add something.
Good.
Ladies and gentlemen, this is the screwed upest way ever to license people. And it has been. When I walked in the door 11 years ago, about 10 years ago, I looked at this and I said, what are we doing here? This tear-off portion, this 23 spaces down, and the dealer writes termination across it and sends it in, and the salesperson doesn't show up with this. This is craziness. This is absolute craziness. If all of you solve this in the next 2 or 3 years, I mean, this is the primary thing you should try to solve, because the way we need to license salespeople and we need to do background checks on salespeople, but the way we get there is stupid. It's silliness what we are doing here, and it has been for a long time. We've got to figure out a way to fix this. Now, one of the things y'all need to know, certainly within a few months, 6 months, the Auto Industry Division is probably going to
highly.
start doing license renewals, salesperson license renewals online. We are fairly close to that. I think it's 3 or 4 or 5 years before we do all licensings online, because it gets very expensive with what we have to do that. But once we start doing things online, everything online, it'll solve some of this. But this red license tear-off section is, I'm sorry, it's pure silliness. And it's been for 10 years. And trying to figure out a better way to do it. We have so many, for 10 years, at least half of the negotiations that I have done for violations has been unlicensed sales. And you can track some of the unlicensed sales back, some of them, to this silliness that we do here. So this regulation, this proposed change, I think, does take a step in a better direction, but it's not the solve. But it does take a step in a better direction. So, I'll get off my soapbox. I wanted to end with that.
So I have a question on the salesperson when he comes in to transfer and he has 4 months left on his license, but he doesn't have the bond. I'm not sure that a bond, you can get a bond for 4 months or for the remaining. I think it's going to be a year. And this is a problem that we have occasionally to match up your all's expiration date with the new bond. So in that case, can the license be a year from when he transfers?
No.
Nope,
So,
sorry.
so then the salesman's going to be stuck buying a bond for X period of time and then having to buy another one.
And
when it renews.
unfortunately, when there is a transfer, we can't
Okay.
break the law because they have to have a bond in place. If
Right,
they
no,
don't
I'm
have
not-
a bond in
I'm just
place,
saying that-
we can't issue you a license.
I'm just
So,
saying if the
yeah.
license, if the term can be modified on your guys' end.
Well, they could do an original instead of a
It's in
transfer.
statute, it would require statutory change.
You know, I mean,
So they could do
An original application.
well, but then it's an application, right?
Yeah, there's more money.
Yeah,
There's also that major choice that somebody could make, and if you guys propose this, I suppose we could try it, which is dealers can't cancel bonds.
I'm not aware of any scenarios in our office, and I'm not in the bonds day to day, that once the bond is issued and it's in force, I don't know that there's unless there's a really good reason, I'm not sure there's any rebate that we do with any bonds,
I mean, I
or
don't
cancellation or refund.
I don't have a lot of turnover, thank goodness, but I've never canceled a bond. In 35 years, I don't recall when we've had a salesperson leave that we've ever tried to cancel it.
There's a very large franchise group of dealerships that goes through quite a few salespeople, and they make the salesperson pay for their license, and they pay for the bond. And then when that salesperson isn't with them anymore, they cancel the bond. We get the notifications,
Wow.
like, you know,
They
that,
pile up.
and that particular one, because that bond company really follows the law and sends us notification. There's a lot of bond companies that do not, and we can't force them to because we don't have jurisdiction over bond companies. So that's why we wanted to look at it when there's a transfer. If it isn't, I mean, a reissue or a transfer, we need to look at, do they have a bond in place?
If it's a new car salesman, I'm not too worried about it then. Just kidding.
Yeah, just so you know the magnitude of this, when I didn't know the magnitude, and someone said, you should go over to so-and-so's desk and see the pile over there. So I went to so-and-so's desk, and there literally was a foot-high pile of bond cancellations from 2 mega dealerships. And so they're getting money back. And every one of those sales guys is walking in without a bond. And if you're right, Todd, I mean, it would be worth finding out. if the bonding company you work with, which is major, can't,
We don't refund salespeople when they cancel like that.
But
I
can-
mean, just a transfer.
could you issue a bond for 4 months?
No. Generally not. I believe that to be true. I think they're a year. Because we tried to do an interim bond recently and wouldn't do it. It's for a year.
I have
You know
to
if you
inquire
can.
within the office. I don't know offhand. I know everything we do is with one company,
Yeah,
but I don't know whether they do partials or not.
that's kind of a major understanding that we should get, because if we're sticking the sales guy with the need to have it, which the law does, and they can't even get that 4 month gap, then we virtually are going to eliminate the reissue and have to go with what John says, which is like a new application.
Well, wait a minute.
No.
I think
You sure?
that if there's a 4 month left on their sales license, we're gonna reissue the sales license. And if the bond's good for that 4 months plus the rest of the time, why wouldn't we take that? Because from a consumer protection, they're covered.
Oh, wait a minute.
Now,
We'll take
Yeah.
then when the new license, the renewal is, what happens, that salesperson just loses that 8 months.
Right.
And what is a
Correct.
year-long salesperson bond? 80, 90 bucks
90.
generally? Yeah.
Okay, so that's how it would work.
And if the dealer cancels it, the salesperson didn't pay for it in the first place, so technically he's not out any money.
Correct.
And the new dealer may pay for it. I mean, so it's hard to tell who's gonna be hurt financially on that
Yeah.
transfer.
So, this will probably reflect my low level of knowledge on bonds, but how do we base the bond? The bond is there in case the salesperson did something wrong. It can make either the consumer or the dealer whole. So, in legal malpractice, it's based on the claim. It's not when the client you had, it's when they make the claim. So if they make the claim after you retire and you're no longer insured, that's a problem. Is it the case that when a salesperson terminates from service that you can no longer make claims against that bond, or by canceling is the dealer just accepting responsibility for it?
The bond,
We have been told by bonding companies, Chris and I had that bond, we talked to one bonding company, a fairly high up person. That bond, they will pay off on that bond. Remember, the bond can only be open to a finding of fraud by the Motor Vehicle Dealer Board or the Court of Conflict Jurisdiction, and they'll pay on that bond for an infinite time of.
Okay, so they're
That's what we
covering
were
the
told.
term of the wrongdoing, not the term of the claim.
Correct.
Right, and
Okay.
sorry, since you're in the room, I'm gonna use you as the example. There was a time where Mr. Perkins had to open up a salesperson's bond and make a claim against it, back in the day. And it covered,
Okay.
it was what, 2-3 years later when you
Yeah.
finally were able to
Yeah.
make some sort
Yeah.
of claim against the bond, and it covered.
But ultimately, there's no downside for this major group to go canceling because they still have the protection and then they get a couple dollars
Correct.
back on because these things aren't that expensive to begin with.
Correct.
Correct.
Okay.
Yeah, most of our out of trust, the finding of fraud is years later, so.
Mhm.
Right. So with all of that kind of the problems, does anybody have any issues with this proposed rule?
And so on the old one, number 4, was any salesperson, wait, that's not it. It talked about being able to go to work as soon as the notification was put in. Actually, I just had it.
The number 2 on the old one, is that what you're looking for, Todd? Number 2 on the old one?
Correct, yeah. Yeah, thanks. Thank you.
Sure, no problem.
Yeah, so number 2, does that appear any place in the new one? I think in number 5 in the new one, it says that it has to be displayed conspicuously. I think if we can negotiate something there so that as soon as the notification is there, the individual can go to work
Well,
would help the salesperson, if I'm reading that correct.
And part of the problem that we have run into at the division is, people will always claim, we dropped it in the post office box and you didn't get it, auto industry division? You know, so we were trying to make it so that there was a bright line. You have something to post conspicuously on the wall to show that Chris Rouse is a licensed salesperson at your dealership.
So I agree that putting something in the mail isn't probably notification, but can we put some wording in 5 that allows, so if a dealer drops by the transfer documents, does he get a hard copy of his license right then?
Generally, yes.
Yeah,
Generally.
if everything's in order.
Yeah.
Right. Which would have to be for an accurate notification too, that'd still have to be the same.
Because the background's already been done.
Yeah. So,
It's technically one of the quickest things we
Right,
can
yeah.
do.
I'm just thinking of dealer that's a distance away that FedExes the documents and doesn't want to pay for FedEx. I mean, just trying to think of an example where it would occur where you'd have the documents, but it'd be days or mail or whatever before the hard copy gets back to the dealership.
What we have done to accommodate in circumstances like that, like let's say it's a Durango dealer, and they FedEx a transfer to us or whatever, we will email them a copy of the license the second that we print it, so they don't have to wait for it to get mailed to them. They can take that copy that came off of the email and post it and say, okay, Chris, you can go out and sell cars.
And that will suffice
Yes.
for the division.
Yeah.
So in reality, once an accurate notification has been made, they really are able to work. Is that what I'm understanding?
Well, we have to issue something first.
Yeah, you have to
I
have
think-
something.
No, but I mean, but it's issued within a very short, reasonable time. I mean, it's either handed to them when they notify in person, or it's potentially emailed once you get the documents.
99 times out of 100, it's that day. 95 times out of 100, it's within an hour or two. Okay?
So can we put that in this then?
Well,
That's good.
here's what we are trying to accomplish there. I got to tell you, honestly, we're trying to accomplish, and I don't know how we're going to do this, but this unlicensed sales is significant. It's a significant issue. The board spends and the division spends, I mean, tons of time investigating unlicensed sales. And this, I think, helps a little bit with that, is that you can't sell until that license is in your hand or the dealer's hand, and hopefully it's on the wall, and then go for it, okay? And we need to do our job internally, so we do not, retard commerce for that person to be able to sell. But if we are doing our due diligence, we're going to do that within that day, generally speaking. But to give anybody else any other leeway, I don't think is good business for us, because we had one last week that came in and said, well, we put it in the mail, and as soon as we put it in the mail, we put the guy on the floor because that's the way it was. Well, that's the way it was 10 years ago. If you mailed the application, you could start working. That went away a long time ago. So we're trying to get away from that mentality. You know, you can't drive a car until you have something in your hand. You can't sell a car until you have something in your hand.
So how's the email or the online renewals, will that work for transfers also?
Well, the answer to the question is eventually. I don't think the first step has transfers involved. The first step is for renewals of salespersons.
And transfers are going to be a unique beast when we go to eGov because of multiples.
Yeah.
So we're gonna have a lot of things to work out, because I could have 5 different salesperson licenses and which one is getting transferred and what's the time period's gonna be and all that. So it's gonna be a little bit complex. So we're trying to go for one of the easier things, and that's renewals, just straight up renewals on eGov. And it's gonna be fantastic. Absolutely fantastic when we get there.
Well, with the explanation and the education that I just received on the renewal, on the process and the timeliness of it, I withdraw my opposition. Reluctantly, but.
Well, the thing about it is, in this particular issue, Todd, your clientele, within reason, should hold us accountable. Within reason. That we turn these things around, because it's a pretty easy thing for us to do. As long as your clientele is being reasonable.
Yeah, not coming in at 5 minutes to 5 on a Friday before a 3-day weekend and,
Well, and realistically, if you have a dealership that's remote, or you have a dealership who has a really glaring need, or whatever the circumstance, and you think that, by saying to that dealership, well, why don't you ask the division to please email this to us? That's an opportunity that we have that notice. If we don't know that it's that important, it's just gonna go in the mail. I mean, because that's the standard operating procedure. But, you wouldn't want every time. We didn't add anything like that here because we don't want to obligate ourselves to every time. But
When you email, is it a copy of the license they print out or just permission?
Yeah.
Oh, so it's actually.
precisely. We just scan in a copy of the license and email it over to the dealership, and then we put the actual hard copy into the US
okay.
mail and get it out.
So does that extra transfer shit?
You said it correctly, yes, sir.
Is that part of the email? I'm just kidding on that.
everything is.
Well, and I think once we issue that license, whether or not we put it in the mail or we email it, as long as we issue that license and the dealership knows this license, are we gonna hold somebody accountable to 5 and take tasks to them? Probably not. Where we're gonna hold people accountable to 5 is the people that we haven't issued the license yet and they're putting people on the floor. I mean, that's really the intent of 5.
Okay. Thank you.
My business manager is so analytical, she likes to keep them all alphabetized, so when we get a new one, she's got to rearrange them, so it may not happen just right then and there. I'll tell her she's just gonna have to throw it in there and live with it. Yes, oh, this will make her crazy.
Questions, concerns, further questions, concerns? So with that explanation, Todd, are you more comfortable with the proposal? So, let's assume that we're moving Rule 5 over. Now, here's what I'm going to propose, is that Leland and Brad are going to be able, because there's not very many changes.
Not many.
Leland and Brad are going to be able to make some changes to this, and so I assume that nobody wants to come back on Friday.
Correct.
So if we make a commitment to this group, that we email out the changes.
Right.
To this group, not to everybody, to this group, by close of business on Monday or Tuesday.
That's doable.
Okay, Monday or Tuesday, and then give this group a day or 2 or 3 to look at it and say, I'm okay with, that's what we talked about. And if there's no come back and say, no, I'm not comfortable with that, then you turn around and start the process, the real process. I'm just rambling here, is that doable?
I think I would prefer to make it close of business on Friday.
This coming Friday or next Friday? This coming Friday.
Yes, because, again, we have a strict timeline to upload into the Secretary of State's office, and I don't want to go back. So if we're in Just because if anybody has comments, then there'll be a very rapid turnaround. So if I get it sent out by Friday, I'm certainly going to need it back, any comments or concerns back by Monday at noon or something. And hopefully can get them by then.
Is everybody comfortable with that? And then we start the real process of
Yeah,
the blast and
Move it up.
and moving it up with the Secretary of State's office and all of that
Right.
process.
Yep.
I just wanted this group to have the opportunity to make sure that you're all comfortable with the changes that were suggested really got there.
How many days out does it have to be posted before it can?
We have to have, it's about a month. It's the fact that there's only certain notice points in the month. It has to end up in the register, okay? And that only comes out twice a month.
Right around the 15th,
Around
14th, 15th, or
Right,
16th.
right.
Each one.
So we have a very limited.
To get it in the register by then.
Yeah.
Okay, any other issues before the group? All right, we're gonna go ahead, Steve.
Well, I don't have an issue, but since this is close to your last, it's been an honor and a privilege, and I appreciate your tutelage all these years.
Thank you. It's been my honor and my privilege.
Tremendous leadership.
Thank you. So we will conclude this meeting at 4:40, Wednesday, September 4th. Thank you all very much.
All right.
See you guys.